Okay, good evening, everyone. My name is Bill Askin, for those of you that I don't know or have not met. And tonight we're kicking off a new initiative that we put together for this year, and that is a monthly question and answer session with realtors invited throughout the state that we've done business with or hope to do business with at some point. My name is Bill Askin. I'm a partner with the law firm of Askin and Hooker. I am a real estate attorney. I've been practicing primarily, almost exclusively real estate law for over 30 years now, all in New Jersey, and handle a lot of residential real estate transactions, some commercial transactions. We do general business transactions, and if you've been selling real estate for quite some time, you understand also the needs of your clients sometimes include land use and permits and variances and development needs, property tax appeals, landlord-tenant issues that come up, and we handle all that kind of stuff. You know, the bread and butter, vast majority of our business is residential transactions, but we do provide full service real estate legal services. Um, our main office is in Sparta in Sussex County, New Jersey. We've got 5 attorneys in that office, and we are a full service law firm, although my part of the practice is limited to real estate these days. We also have a satellite office in Beach Haven in Ocean County, and we have 1 attorney there and 1 paralegal. That's me. So I split my time now between the two locations. This is the first of our Q&A sessions. First one we've done. We plan to do one every month on different topics that are kind of unique to real estate law, kind of an informal question and answer style. So if you have any questions while we go through this presentation during the next hour, please feel free to type them in. The Q&A button should be at the top of your screen, and a panel kicks off to the right, at least on my computer. Type your questions in there, and I'll be happy to address them as I can as we go through the presentation. If everybody should know, we are recording the presentation tonight, and the final recording will be up on our website and YouTube channel in the next couple weeks. And today's topic, or this evening's topic, is use and occupancy agreements. Again, if you've been selling real estate for any period of time, you've probably come across that topic, that issue. Generally, it's either a buyer wants to occupy a property before they close on the property, or a seller wants to continue to occupy a property after they close on the property. So after the title is transferred to a buyer, the seller wants to remain for a period of time, or before title is transferred to a buyer wants to occupy the property. And I'll tell you real quick, the general rule, or my general advice in respect to use and occupancy agreements is, and this probably won't surprise many of you, my advice is don't do it. Don't use them, right? Because they are and can be a nightmare. The clients certainly can lose leverage in terms of getting to the closing table, which I know is important to all of you. And unless you get to the closing table, your client's needs aren't satisfied. The contract is at risk of not closing. And, everybody, at least on this call, is at risk of not getting paid. So use that sense of urgency when it comes down to the wire. Again, my best advice is to push to get the thing closed and avoid getting a buyer into a property before the title transfers. The second thing is with what we've seen probably in the past year more than ever before is sellers wanting to remain in a property after closing. And what I see a lot is it's really as a result of the buyer needing to close before their rate lock expires. Again, you may or may not have seen that over the past year or so, but in this economic climate where rates have been rising significantly, when we come close to a closing date, oftentimes the buyer risks losing their rate, and the new rate could potentially be, one or two or even more than two percentage points higher. The cost of extending the rate lock to getting that extended can be exorbitant, and it could, in many cases, put the actual closing itself in peril if we don't actually get it closed. And what we've seen oftentimes is the sellers are not ready to close, right? Or the sellers at least aren't ready to move out of the property. So that is something, kind of a new phenomenon, or an increased phenomenon over the past year or so in this climate. And if you see that again, you but my best advice is don't do it. But if you're going to do it, if you have to do it to save your closing for your buyer and give your seller time to move out, I will give you a few pieces of advice as to how to put the best agreement together that you possibly can to protect all the parties involved. And what we're generally talking about with use and occupancy agreements, you know, first of all, make sure you have a good real estate attorney involved in your transaction to prepare that document. Like I said at the beginning, I have been primarily or almost exclusively a real estate attorney my entire career, and I've done literally hundreds of use and occupancy agreements. In fact, I went through my file of old agreements before getting on the computer tonight to give this presentation. I've got over 100 of them, right? So if I have an attorney on the other side of a transaction that's never done one and they need to do one, they'll ask me to prepare it. And there are certain things that, even as the realtor involved, that you want to make sure are in there to protect your client as well. So, like I said, if you can't avoid a use and occupancy agreement, first thing is to just make sure, always, to your clients, make sure they're aware that they do add significant risk. Risk to the buyer, risks to the seller, risks to you guys, the realtors, and even the attorneys. Um, there's risk to the seller for letting a buyer in before a closing, and there's risk to a buyer if they let the seller remain after the closing. Um, Once anybody owns a property that they don't, I'm sorry, once anybody occupies a property, right? There's somebody living in a property that they don't own, whether it's a buyer before a closing or a seller after closing. That scenario creates a new legal relationship, right? A new relationship is created, and it's called, I could ask you to all say it, but I don't think we can hear each other. It's probably too many people here. It's a landlord-tenant agreement, right? Whether you have a written agreement or not, you've established a landlord-tenant relationship. Now, what are the rights? What are the responsibilities? What are the liabilities of the parties in that relationship? And we're talking about important things, right? Like rent. Does the person occupying the property, are they, responsible for paying any sort of rent? Generally, I would say yes, they should be paying some sort of rent. Who's going to cover the insurance on the properties, right? Is it the buyer, the seller, the landlord, the tenant? Who's responsible for insuring that property in case of a hazard, a loss, a complete loss, a slip and fall? Somebody falls on the property and gets hurt and they sue, a discrimination claim. Who knows? A lot of things can and do happen on property, on real estate throughout the country. So who's responsible for incurring the liabilities, the insurance coverages, and the costs for insurance? Who's responsible for the utilities? Who's responsible for the taxes? What if there's a new assessment? What if there's a homeowners association or a club dues? Who's responsible for maintaining the home? Right? Who has to cut the grass? Who's got to plow the driveway or remove the snow? Who has to clean the gutters? What if it's something more significant than maintenance, right? What if it's the roof starts leaking, the hot water heater breaks. Who's responsible for the appliances? There are a lot of issues that, unless you address all of these various issues in some sort of an agreement between the parties, you're opening yourselves up to potential liability as well as creating risks for your clients. So perhaps the biggest issue um, or risk, more so to the what would be the landlord in this situation, the risk to a seller of letting a buyer in early, or the risk to a buyer of letting a seller stay after closing. The risk created there is, are you exposing your client to the New Jersey Landlord Tenant Act and the New Jersey Anti-Eviction Act? And I'll tell you right off the top, the one thing you want to make sure that you do when creating a use and occupancy agreement is to make certain that you are defining that agreement in the best way possible to prevent the relationship between the parties from being subject to the New Jersey Landlord Tenant Act or the New Jersey Anti-Eviction Act. Because in New Jersey, like many states, the act, the landlord tenant laws are designed to protect the tenants and protect their right to housing and to protect their opportunity to have a roof over their head. And agreements that are subject to that act create all kinds of challenges, hurdles, risks, and processes that need to be followed to the T in order to get a tenant removed. I don't know if anybody here has ever been to landlord tenant court or been involved in trying to get a tenant removed from a property, but I'll tell you, it takes a minimum of 2 months, minimum of 2 months. And any tenant that is protected by that act is entitled to remain in the property as long as they continue to pay rent and don't breach or break the terms of their agreement with the owner. The tenants are protected, and the landlord, if it is under a landlord-tenant relationship or subject to the Landlord-Tenant Act, landlord does not have the option of a self-help eviction, right? So if if the buyer gets in before the closing on a buyer occupancy prior to title transfer for whatever reason, and the buyer then doesn't close for whatever reason, the landlord is stuck with that buyer as long as that buyer honors the terms of the agreement and is paying rent. So tenants can only be removed for cause in New Jersey. That is failure to pay rent or otherwise breach the agreement with the landlord. Basically, in New Jersey, residential tenants are protected for life. Protected for life. You have a 1-year lease. Does the tenant have to move out after 1 year? No, they get to stay month to month forever, unless the landlord has cause to have that tenant removed. So it's important to have documents and agreements that avoid establishing anything that could be construed by the courts as a lease under which the tenant is protected. Now, that's challenging. Sounds challenging. It is challenging. I can tell you, I can't even guarantee to whoever's the owner of the property that the agreement that we create is not going to be subject to the Landlord Tenant Act or the Anti-Eviction Act, because basically, under the law, all agreements by which someone is legally occupying a home, it's only residential, but by all agreements or arrangements by which someone is legally occupying a residential property which they don't own is subject to the Landlord Tenant Act. The only exceptions to the New Jersey Landlord Tenant Act are hotel guests, motel guests, or guest houses rented to transient guests or seasonal guests. And that's how, like those of you that practice down along the Jersey Shore area, seasonal tenants, you have a lot of seasonal tenants that maybe rent for a week or two. Most all of you now are familiar with VRBO, right? Those type of relationships would be considered transient guests or hotel or motel guests or seasonal tenants. they're not subject to the Landlord-Tenant Act. And that's really about it. So a key clause that honestly, I very, very rarely see in any use and occupancy agreement, a very key clause should be that this agreement is not a residential lease subject to the New Jersey Landlord-Tenant Act or the New Jersey Anti-Eviction Act. And then buyer, if it's the buyer, just do that one first. Buyer is occupying the property as a transient guest only and not as a tenant. And therefore, the protections extended by the New Jersey Anti-Eviction Act do not apply to this agreement. Or if the seller is going to stay after the closing, the agreement should state the seller is occupying the property as a transient guest only and not as a tenant. And therefore, the protections extended by the Anti-Eviction Act do not apply to this agreement. That mimics the language in the law, a transient guest only. And I think that's probably the most critical thing that you should look and confirm is in any use and occupancy agreement that you become involved with. Even if you're not the attorney, right? If you have an attorney who's doing a favor for a friend and the attorney's a litigator or whatever, and you see it, if you remember that phrase, you would remind your attorney to please put that phrase in there. But will that suffice? Again, I can't guarantee it would. Can't guarantee it, right? I would suggest you'd probably get different results in different counties around the state. I would think the more liberal counties and liberal judges would say that is not sufficient. I would think a more conservative county or judge would say that is sufficient, but no way to predict. But it's in my mind, it's the best you can that mimics the language in the law. If the judge or your case is determined that whoever is the tenant in that case is protected by the act, again, they can only be removed for cause. And I have to refer to the actual law again, but the primary cause for removal would be if they don't pay rent, right? If they don't pay rent, you will eventually be able to get them out. But even on a failure to pay rent, it would take minimum 60 days to get them out. And usually these agreements, right, they're for like maybe a week tops, you know? I mean, I've done some for as many as a month, but, for 5 days or a week, and then all of a sudden, there's all kinds of reasons, I'll cover this later, why the buyer might not close or might not be able to close, and they have nowhere else to go. They've moved in. How are you going to get them out? It's going to take a couple months, most likely. So failure to pay rent, disorderly conduct, damage or destruction to the property, these are causal reasons to get them out in any landlord-tenant eviction case. Damage to the property, violation of the rules and regulations, violation or breach of the contract, failure to pay rent increases. Landlords do have the ability to increase the rent a reasonable amount annually. And there are several other legal reasons, but they're not easy to prove. And you have to put the tenant on notice. You have to give them an opportunity to cure the defect or the breach of the lease before you can file for eviction. So it's a process that, as realtors in the transactional business, you don't want to get involved in these things, and you don't want to expose your clients to these types of things. So, like I said, the risks that are involved, I'll cover some risks. And just by the way, I don't see any questions in the Q&A yet. So just a reminder for anybody that joined late, if you have any questions, we'll just type them in. Just click on the Q&A button. I think it should be at the top of your screen. And if you have any questions, you can put them in there, and I'll address them as we go through the presentation. And we'll be done by 45 minutes or so, 5:45, 6 o'clock at the latest. The risks, obviously, I started with the Landlord-Tenant Act, and then what if they don't leave, right? So what if scenarios, right, that I've seen most of these. What if the buyer moves in early and they get cold feet for some reason, right? You're stuck. The buyer gets cold feet, they move in, they don't want to close. What if they can't get their financing for some reason, right? As fast as we talked about that earlier, rates rising so fast. And if they lose their rate lock and the sellers let the buyer in, and now they find out that their payment is $500 or $1,000 or $2,000 more than they anticipated, they may not want to make that payment, or they may no longer qualify for the loan. And if they're in the house, now you've got an issue, right? And then more kind of like situational factors, right? So they move in, and all of a sudden, after a couple of nights in the home, they realize that the house is a little closer to the railroad tracks, right, than they thought it might be, or the airport, right? You hear the airplanes landing at 5 or 6 o'clock, and they're taking off at 6 o'clock. What if they move in and they get into some kind of a dispute with the neighbor, right? Or some issues, they got words with the neighbor, like, oh my God, I like, the little kids, our kids don't like the neighbor, it's kind of these situational things. We see these things happen. What happens? You let a buyer in early in, if you let a buyer in March of 2020, and they're supposed to close in April of 2020, right? Now it's COVID, right? What do you do now? Now you can't get in court probably for a year to get them out if you had to, right? The courts were, closed. You have a buyer in a property that didn't close on the property. The title company, you can't get a hold of anybody at the title. Nobody's working, that probably the worst time to let a buyer in early. What if the buyer just, moves in and everything's good, and then they get sick or they lose their job? Can you get your mortgage if you lose your job? Nope. And what if, I've had this happen. What if one of the parties passes away? What if the buyer moves in early and damages the property? They move in and they put the couch through the wall. Moving in, there's a big hole in the wall. Who pays for that? I mentioned a couple of these things earlier. The furnace or the boiler dies, the roof leaks, the delivery guy slips and falls and cracks his head open and sues. Who's responsible for that? What if there's a fire? What if the buyer moves in and paints the house purple, right? And then they don't close, and the seller's got to take his house back, and now his house is purple, what if the buyer alters the property? They do something to alter it or remove the deck or for some reason, then they don't close. Same thing the seller side. If the seller stays in the property after closing, I would think the risks are a little bit less, right? It's post-closing, but the seller does something. There's an accident, an injury. What if the seller just doesn't leave? The seller could stay after closing, right? And still something happens in their life, and they say, well, we can't move because our purchase got canceled, right? The house they were supposed to buy and move to, that didn't close, and they have to stay in that. I had one last year where that happened. The seller had to stay. The buyer had nowhere to go. This is honest God's truth. The buyer moved in with the seller. It was both families were in the house for like a week. One time only that's happened. So let's get into then some of the key clauses, and this is probably another reason why a lot of you are on the presentation tonight. And I mentioned the one key clause about buyer or seller, whichever one it is occupying the property as a transient guest and licensee only, and not as a tenant, and therefore the protections extended by the Landlord-Tenant and Anti-Eviction Act. It's, if you want to write this down, it's a statute in New Jersey, NJSA 2A. That's NJSA 2 capital A colon 18-61.1. That's the actual statute. If you Google that, you can look up the statute, and it contains that language. So that's the phrase, very paragraph 1. That's what I put in my paragraph 1 of use and occupancy agreements. Second key clause is to have a start date, and the start date is either the date the buyer moves in for closing, the date the buyer moves in before the closing, right? So if they're moving in today, but they're not closing for a week, today would be the start date. And more importantly, have an end date, right? You want to make sure that there is an end date when that agreement expires and the buyer or the seller has to be out of the property. If the seller is moving in today, but it's before it close or after it, I'm sorry, if we're closing today and the seller is staying for a week, today would also be the start date for the use and occupancy agreement for the seller's continued occupancy post closing. So once we have the clause to accept this relationship from the Landlord-Tenant Act, a start date and an end date, Next, we have what is the payment. I try to avoid calling it rent, right? If you call it rent, I don't know, a judge could interpret that to mean a landlord-tenant situation. So call it, daily payment due. Um, try not to call it rent, and make it daily. The cost of occupancy is $100 a day, $200 a day, whatever it is. Make it daily rent. I think that also helps substantiate the transient nature of the relationship. Don't make it monthly, certainly, because that sounds like a lease to me. That sounds long term to me. I wouldn't even make it weekly. I would suggest daily rent, right? So a cost of $175 per day. And then add a holdover penalty, right? So if if the end date of this use and occupancy agreement is, call it April 30th, is Monday. The end date is April 30th. If the buyer or seller, whoever's in the property as the tenant, if the buyer hasn't closed by April 30th, or if the seller hasn't vacated by April 30th, there is a holdover daily penalty of, in my opinion, at least double. So if it was $200 a day for the use and occupancy period for a week, if the buyer hasn't closed or the seller hasn't left by the end of that 1 week period, minimum double the rent. Depending upon who I represent in the transaction, I've at times secured 5 times. So if it was $200 a day and they're not out, it goes to $1,000 a day for every day that they're not out after the end date. And it also has to be something that your client feels comfortable with, right? So the seller, with a buyer coming in, a rate lock expiring, they're going to, take the risk of letting the buyer in early with potentially a risky buyer, or say they're like, I don't know, FHA or VA or some kind of non-conventional financing. They're worried. Maybe it's 100% financing or 97% financing, and the seller's really worried. You might want to have a pretty severe penalty, right? Like, 3, 4, 5 times the original rate to really encourage that buyer to close on time. But I would say at least double the rate. And then whoever the occupant is, right, whoever is going to occupy, if it's the buyer moving in early, have that person be responsible for all damage during the occupancy. It's a clause that should be in there. So if there's a leaking faucet, or a blemish in a wall, a hole in a wall, a broken window, any damage that occurs during the occupancy is the responsibility of the person occupying, the buyer who moved in early or the seller who stayed after the closing. But then you got to differentiate that again from failure of any structural or mechanical, plumbing, electrical system. Those major issues, a failure of any mechanical, plumbing, electrical, structural, those system type deals should not, my opinion again, should not be the responsibility of the occupant unless they're caused by the occupant's negligent, careless, or reckless conduct, right? So, if the seller stays after the closing, and after closing the boiler goes out, that's really on the buyer's dime, right? The buyer closes, and this is another topic, but it's like as is, right? But it's caveat emptor. Once a party closes on a property, it's as is. So the buyer would be in the position to take responsibility for defect of a mechanical system like that. But make sure that's clarified in there, so there's no issues that come up. There should also be an insurance clause, an insurance and indemnity clause, right? So if the buyer is moving in early, you want to make sure that the agreement requires that the buyer secure a policy to cover their own personal property and their own personal liability. It would be something very similar to, and again, I would avoid using this phrase, but similar to a rentals insurance policy, a renter's policy. That's what it is. I just don't use that language. I just try to keep that word rental, right, out of a use and occupancy agreement. But it would be a policy to cover their personal property, right? If they're taking early occupancy, they're moving all their stuff in. You want to make sure they have insurance for their stuff. And then they would also have potential liability for injuries or damages on the property. They want to make sure they have that liability insurance in place as well. And in that case, since there's not a closing, the seller is going to maintain their existing homeowner's hazard and liability insurance. So I always tell sellers not to cancel their homeowner's insurance until after we've delivered the proceeds of their sale. Oftentimes sellers get kind of excited when, a closing's coming up and we say, yeah, the closing's on Friday, April, whatever this Friday is, it's tomorrow, 25th. And they call today and cancel their insurance effective the 25th. I said, don't do that. You don't want to have an uninsured house. So sellers should never cancel their homeowner's insurance until they have their proceeds in their hand. So walk insurance, indemnity, both parties, and then a walkthrough inspection. This is another critical piece. So if you've ever done a closing, and right before the closing happens, typically the buyer will go and do their walkthrough, right? They'll walk through the property and they'll make sure there's been no damage to the property while the seller was moving out, or that at least that the property is in the same condition that it was in when they made their offer or when they completed their inspections. And for better or worse, oftentimes the buyer does their walkthrough and they ask for something, right? The seller left paint in the basement. They don't want the paint in the basement, or the seller removed the carpeting in the living room and there's stains on the hardwood floors, like those things. You don't want to have a buyer in a property, especially if you're the seller or the seller's realtor. You don't want to have a buyer in a property and then they're living there, and then the day of closing, they come back and they complain about the condition of the property that they already occupy. The walkthrough should happen. The walkthrough that typically happens the day of the closing should happen the day the buyer takes occupancy of the property. Make sense? So the walkthrough inspection and this agreement should say, your use and occupancy agreement should say that the property shall be delivered at closing in its as-is condition as of the date the buyer took occupancy. We want to eliminate any walkthrough issues coming up a second time or a third time at a closing table once a buyer has already been in a property. So again, as-is condition, walk through before the occupancy, and if there are any issues, let's negotiate those before the buyer takes occupancy. I don't want to have to renegotiate or worry about them at the closing. And really, the urgency is there, right? The buyer's urgency is they need somewhere to go. They want to get in early. Let's take care of any potential walkthrough issues and confirm in this agreement there will be no walkthrough or credit or repair requests even considered on the day of closing. Next one. So we talk a lot about payment, rent, security, holdover penalties, right? How are we going to confirm that there's money available from the buyer to pay the rent if they're moving in before closing? Or how are we going to confirm there's money available from the seller if they're going to stay after the closing? And again, another very key element of a use and occupancy agreement should be an escrow and money put into escrow, whether it's with the buyer's attorney or the seller's attorney. I don't care. I don't argue that issue. I don't care if I hold it or the other attorney holds it. We're both beholden to and required to comply with the same rules of escrow and attorney's IOLTA accounts, no matter who holds the money. It's covered by the same rules and regulations. I don't care who has it, but make sure there's enough money to cover the risks involved to your client, whether it's the buyer or the seller. Kathleen is my moderator and says that there are questions in the chat. I don't see them. So Kathleen, if you could tell me how to view the questions, maybe just text me or whatever. I don't see the questions. No questions yet. So if there are, let me know. So the escrow agreement should be sufficient, certainly enough money in there to cover the 7 days at $100 a day, right? 7 days, $100 a day, $700 or $200 at $1,400. But is that enough? Absolutely not. You want to have enough to cover um, the cover the risk of the buyer staying afterward. Um, I'm looking for the questions here real quick. Oh, there it is. Okay. So you want to make sure you have enough in the in an escrow account to cover a potential risk of a occupant staying longer than the agreement calls for. How much is enough? I don't know. I can't tell you how much is enough. I can tell you there's no amount that would be too much, right? At least for the whoever it is that owns the house. Um, I can tell you I have had a situation or a number of situations where there has not been enough. And if there's not enough in escrow, that leaves your client potentially, having to resort to the courts to try to enforce and get a judgment against another party for some money. So um, get at least a few days minimum of a penalty. Whether I start off with like making maybe an extra $2,000 or $3,000 at a minimum over and above the amount of the rent that would be due under the agreement. And then there should also be a security deposit, much like a landlord tenant. In a landlord tenant situation, a landlord can charge 1.5 months rent as a security deposit. So if your rent total is $1,000, your security deposit using the Landlord Tenant Act could be somewhere around 1,500, 1.5 times the amount of the rent due. I think that's probably a good place to start. Again, I wouldn't reference a rental or the Landlord Tenant Act, but I would ask for a security deposit of about 1.5 times whatever the rent due is. Um, and then the other things just to consider and talk about, maybe these things do or do not, maybe they do not need to be included in the use and occupancy agreement and a potential escrow, but utilities, right? So who's responsible for utilities? Typically, whoever's occupying the property is responsible for the utilities. But if the buyer's moving in early, those utilities should be changed to the buyer's name, but has somebody confirmed that that's been done? Hopefully, but maybe you want a little escrow to cover the seller's potential risk of utility bills. Property taxes, who's going to be responsible for that? Oftentimes, most of the time, I would say that's covered by the daily cost of the occupancy. But sometimes we have the property taxes separated out. Make sure that the parties understand who's responsible and that the responsibility is reflected in the use and occupancy agreement. Um, and then finally, um, include a include a include a phrase in the agreement that identifies the party responsible for payment of for damages to the property for rent if the escrow is not sufficient. So, for instance, if the escrow is not sufficient to cover, in most cases, a buyer coming in early is not sufficient for the buyer or to cover the buyer's rent or to cover the buyer's property damage, that the buyer remains responsible for any additional amount due or incurred over and above the amount of the escrow. It's important I just identify the property that's responsible for overruns. Typically, it would be the buyer. Add a clause that if the buyer or the seller, depending upon the situation, make sure there's a clause in there that if somebody needs to file a court action for removal, that the attorney's fees shall be awarded to the prevailing party and paid from the escrow, right? So again, if the buyer's moving in early, they don't close, the seller has to file to have them evicted. Add a clause in there that says that the seller's attorney's fees should be covered by the escrow or covered by the buyer to cover the cost of. And many of you probably know, attorney's fees for a landlord-tenant eviction action can be $2, $3, $4, $5,000. It's a minimum $2,000. So you want to make sure you cover that one as well. Um, Make sure that when the agreement contains a clause that the owner of the property, right? So whether it's the buyer, the buyer who buys a property and the seller stays after the closing, or the seller lets the buyer in early, that the property owner may inspect the property upon 24 hours notice, right? So you don't want to have a situation where the owner of the property can't get in the property. So if you put a clause in there, as long as the owner gives 24 hours notice, who knows what may be going on. But for some reason, their suspicions are raised. There's illegal activity. There's damage. There's uncertainty. The owner wants to have the ability to get in and inspect their property. Another clause that's important is if, in the event the occupants, somebody moves in, and their personal property or possessions have not been removed by the vacate date, right? So the buyer closes, the seller remains after the closing date. The seller then leaves, vacates the property, and leaves stuff on the property. Leaves, I don't know, furniture, um, uh, some plates, forks, paint, whatever. Clause in there to protect your client to say that the personal property or possessions that have not been removed by the vacate date of the agreement, that the owner shall have the right to dispose of them accordingly. Again, you're protecting your client from a cause of action for conversion or theft, or any kind of allegation that the party who left stuff there could potentially make. Another important thing is, this is typically, again, when the seller stays after the closing, make sure that the occupant, usually the seller, it could be the buyer, if they're going to leave, anytime they're going to vacate the property, they have to provide a minimum of 3 days notice to the owner, right? So a lot of times we've had deals where somebody moves to Florida, right? They sell here and they move to Florida. They got a buyer in early, and then if the buyer leaves that property, the seller's in Florida, they don't know, and there's a vacant property that nobody's taken care of. So 3 days notice before whoever the occupant is, the buyer or seller as a licensee, 3 days notice before they vacate. Make sure that the occupancy that's extended to the party is limited to that party, whether it's the buyer or seller's occupancy under this agreement is limited to the seller or buyer's immediate family only. I had that one too. The sellers let the buyers in early, and lo and behold, it wasn't just Mr. and Mrs. Smith. Mr. and Mrs. Jones came with them. Grandma and Grandpa came with them. Aunt Susie came with them. All that kind of stuff. So you want to make sure the occupancy is limited to their immediate family only. Another good idea that we try to do sometimes is that we get the if I have a seller, especially if I have a significant deposit like down payment from a buyer in trust as a deposit on the transaction, we would require that the buyer agrees that the contract deposit shall also serve as additional security under this agreement. So then you're tying that deposit. I mean, whether it's $5,000 or $80,000. If you tie that deposit to the actual agreement, you're creating a lot more leverage in that case for your seller, and a lot more likely that that buyer is not going to, talk about backing out if something happens. And then before I get to the questions, I've got a few questions. I'll just one last little piece of advice. We've had situation a number of times where the buyer wants to get early occupancy or early access to a property to store stuff, right? They don't necessarily need to move in to sleep there. That's probably quite a bit less risky for a seller. And in that case, you just would amend the use and occupancy agreement to make it a storage agreement, a storage only agreement. And again, in that case, if the buyer's not living there, you're lowering the chance of, any kind of a disagreement with the neighbor, or they don't like the neighborhood, or they hear the railroad train at night, or the airplanes, or yeah, it lowers the risk a little bit to the seller. Um, and there are several ways to tighten up the agreement to restrict that the seller is allowing the buyer access to the property for storage purposes only. Typically, in that case, if I have the seller, I'm going to try to restrict storage to the garage only, right? I would prefer that the buyer not move their living room furniture into the living room, right? But limit it to the garage only, or the basement. Maybe I've had the case where there's a walkout basement. They can move stuff in through the sliding doors into the lower level, that kind of thing. But and in that case, again, also you want to make sure that the buyer has adequate insurance in place to ensure their personal property, that they understand that the seller is not um, providing any sort of insurance for the buyer's personal property or furniture. So, well, oh, look at that. Kathleen told me that I could see the chat. Now I can. Um, Repeat NJSA. Yes, that was my first question from Lori. Hi, Lori. NJSA, find it again. NJSA 2A colon 18-61.1. Got that? I guess I could put it in chat, right? There you go. I can, boy, look at that. NJSA 2A colon 18-61.1. Colon 18-61.1. Yeah, that should come up if you just put that into your Google bar, that statute. Let's see what we have next. UNO in my market. This is Deborah Lyons in my market. UNO in the accepted offer did not charge rent for 2 months to make their more from. Well, I, so I guess you're telling me in your market, it's more typically a buyer's market then, right? If the seller's willing to let somebody in free for 2 months, did I get that right? The accepted offer did not charge rent for 2 months to make their offer more appealing. Or was that the buyer was going to close and let the seller stay free for 2 months? Maybe that's it. Somebody's nodding their head. Is that what we're talking about there? Yeah, I mean, that's fine, but regardless of the case, whichever one it is, I would certainly have sufficient security money, right? A security deposit in escrow and some sort of rent that kicks in, and maybe it's a little bit of a penalty rent if they haven't vacated within that 2 month period. So if you're going to let them stay for 2 months for free, that's okay. It's $0 per day. But if the occupant, whether it's the buyer or the seller, is not out by that date, the cost of the occupancy shall begin to accrue at $250 a day. And then you can add a series of penalties, right? $250 a day for the first week. If they're not out by that week, $300 a day. Just keep going up. But keep it as my advice is keep it as a daily rental fee. I'm sorry, a daily occupancy fee. Daily occupancy rate of blank per day. Is there a time limit for a UNO? No. I mean, the longer they go on, I'll tell you this, there's no time limit. But the longer a UNO goes on, the more likely it is that it will be interpreted to be a lease covered by the Landlord Tenant Act. So the shorter, the better, right? And all these little things, pieces of advice I'm giving you, it's the cumulative effect of all these things that lead to a judge interpreting whether or not you're subjecting your clients to the Landlord Tenant Act. If you had if you had a UNO for a year at, $2,500 a month, that's subject to the Landlord Tenant Act, without a doubt. If you have a UNO for 6 months at $1,000 a month, that's subject to the Landlord Tenant Act. If you have a UNO for, a week at $100 a day, that's not. And then you get into a gray area, right? The closer you get to a number of months as opposed to days, the closer you get to subjecting your clients to the Landlord Tenant Act. And if you have the buyer moving in early, maybe that's not really a concern, you know? It's a concern for whoever the owner of the property is, right? Or if you have a seller staying after the closing, maybe you're not really worried about that. But if I'm the attorney for the buyer, he's going to own the property. I'm going to be very worried about that. My sister, I'm sorry, goes on. My seller needs the cash from her closing to even have deposit money on her next place and would like to be able to stay for 2 months while she finds her next place. So, I mean, again, it's not black and white. 2 months, I think, with a properly drafted use and occupancy agreement, I think that can and could work. Can a tenant stay in place indefinitely, even if the lease stipulates no automatic renewal? Yes. Tenants are protected. Generally under the Landlord Tenant Act, a tenant in a property can stay forever. Once they're in, as long as they're paying rent on time and not otherwise breaching the lease, that place is theirs for life. Now, how do you protect against that? If you're the landlord, you raise the rent a reasonable amount. And my advice to my landlord clients is raise the rent every year, 2, 3, 4%. The statute can't tell you how much, right? Because the market conditions change. So the statute says a reasonable amount. And the arbiter of what is reasonable is a judge. And there's a form letter that needs to go from the landlord to the tenants annually that says, hey, effective, on the first anniversary of your lease, the rent's going to be increased 2% or 3% to this amount. You're advised accordingly. If you don't pay the revised amount, we will seek eviction. That's a reason to evict is failure to pay rent or failure to pay a reasonably increased rent. But if the landlord raises the rent 25%, that's not a reasonable amount. The tenant can continue to pay the rent that the initial lease said, and they're protected. So it's a process to go through, but literally, here's where I get in an issue with realtors and with residential closing sometimes. It's a residential property. The seller is selling it, but the seller doesn't live in the property. It's a rental, and there's a tenant in that property, right? The buyer generally has to buy that property subject to the existing lease. However, if the lease has expired, as long as the written lease has expired, in that case, the tenant can be evicted by the owner of the property upon 60 days notice. So most notices to tenants are 30 days. If you have a listing or you have the buyer for a property where there's a tenant, the owner of that property has to give that tenant 60 days written notice that they are under contract to sell the property to a buyer who intends to occupy the property as their primary residence. Again, those are all critical elements of that notice. So make sure you get good legal advice if you're in that situation. I've had the situation a few times where the owner gave the tenant 30 days notice. Not sufficient. For that purpose, it has to be a buyer intends to occupy the property as their primary residence, under contract to purchase, with 60 days notice to the tenant. Sent certified mail, return receipt requested, so you can prove that it was done the right way. That's it. That's it. I don't see any other questions. We're going to plan to do these every once a month or so. Next one will be towards the end of May. I think we had a date, May 24th, maybe. We'll put if you're still on the email list, you'll get a notice of the next scheduled one. I think it's towards the middle or end of May. And I'm thinking I might cover escrow agreements. We have all different types of escrow agreements. That's basically money held from the buyer or the seller, or occasionally both parties, to cover things that need to be done after the closing. Again, my best advice is not to have an escrow after the closing, just like a use and occupancy. As a lawyer, you don't really want these things dangling out there, but we have to do them a lot. We have escrows for, in Northwest Jersey, at least, septic systems. Down the shore, we have escrows sometimes for wind or storm damage. Certainly, we had many escrow agreements after the superstorm a few years ago to cover repairs and roofs that blew off houses, things like that. So post-closing escrow agreements, it's an issue we think we could spend about an hour, again, topic just like this, a more casual question and answer. And I don't see any other questions. So again, I'm Bill Askin. Thanks for tuning in. We did record the session. It will be up on our website and on our, I think, our YouTube channel. If you have any questions in the meantime, I can be reached in the Sparta location at 973-729-7711 or in Ocean County at 609-342-0603. And I am bill@askinlaw.com. So have a nice evening, everyone. I hope you found this to be useful, and I hope you will tune in again sometime soon. Have a good evening.